The numbers in copyright cases are so exorbitantly high that they cannot function. They physically, emotionally cannot function with that threat looming over their head. And so far, the how much is a very large amount of money, 4 to 5 to 6 digits, according to copyright law. All I can do here is decide for myself in front of your own eyes whether I agree with this letter to the House Judiciary Committee or not. So, welcome everyone. Which story do we think we want to start with? How about the one that I want to start with? I'll be a little bit selfish here. I want to find out what in the world is going on with the C.A.S.E Act, because when I originally reported on the C.A.S.E Act, I thought it sounded like a decent idea that there would be a powerful new small claims court in the U.S. Copyright Office in Washington, D.C. that would give copyright trolls, according to the Electronic Frontier Foundation, a faster, cheaper way of coercing internet users to fork over cash settlements, bypassing the safeguards against abuse that federal judges have labored to create. Well, let's read what the Electronic Frontier Foundation has to say about what these federal judges have labored to create. And keep in mind, this is my very industry. So this is their letter that they wrote to the House Committee on the Judiciary. Dear Chairman Goodlotty, Ranking Member Nadler, and members of the committee, we are attorneys, engineers, and activists who defend internet users, thousands of your constituents who use the internet at home and work every day against abusive legal threats. We write to express our grave concerns about the Copyright Alternative in Small Claims Enforcement Act, the C.A.S.E Act. Though it's well-intentioned, this bill would reignite the nationwide problem of copyright trolling, just as the federal courts are quelling this abusive practice. And real quick, before we go into what they have to say about copyright trolls, let me tell you my experience. What they're going to talk about are plaintiffs who file copyright cases against people that they are accusing of file sharing, usually via BitTorrent, possibly some other means, but my job is mostly involving BitTorrent. If you're not familiar with BitTorrent, BitTorrent is a file sharing protocol. It's a peer-to-peer protocol. It was developed in the late 90s by Bram Cohen. I remember donating $5 to Bram in 1999 or something when I was in college and engineering school because I thought it was so cool, and I got a letter back from him, like a one-liner, like, oh, thank you very much. Very much like we do today with $5 sent to a patron, from a patron to a channel. Thank you very much. So it's a really cool circle that it went from me being in engineering school to now being a copyright attorney defending when these plaintiffs collect a list of IP addresses that are allegedly sharing pieces of a copyrighted work. Then they sue a John Doe in court, get a subpoena to unmask the identity of that IP address, which of course is a subscriber and not automatically the infringer. Now, the subscriber has to go and conduct their own investigation. Well, who used my internet connection? Maybe it was the subscriber. Maybe it was not. What happens to these innocent people who are caught up in the net of this copyright investigation? And that's where kind of the awful things come in. I have seen people who I believed were innocent still get nailed to the wall because the numbers in copyright cases are so exorbitantly high that they cannot function. They physically, emotionally cannot function with that threat looming over their head. And they are very motivated to settle their case. Even as much as I try to counsel my clients to at least go into court and defend a little bit, we really always come down to one or the other, that we either have to fully defend or we have to completely devote our resources to settlement. And that is a terrible position for an innocent to be in. Now, a person who's guilty, we can have another conversation. If they have actually taken something and it wasn't theirs to take, is that theft? Theft of a digital good, is it theft? Okay, so let's maybe back off of the word theft. Is it infringement? Yeah, it's infringement. And is that compensable? Forgetting the amount, is it compensable? Yes, I have to agree it is compensatable. So if we go that far, and if we all agree, and I'm not saying you have to agree with me, but if we all agree that that's compensatable, the only remaining question is how much. And so far, the how much is a very large amount of money, 4 to 5 to 6 digits, according to copyright law. It's not like getting a speeding ticket. Now that's more of a moral disagreement than it is a legal disagreement. And so all I can do here is decide for myself in front of your own eyes whether I agree with this letter to the House Judiciary Committee or not. So hearing my perspective on what copyright trolls are, let's return to this document and see what they have to say. Copyright trolls are plaintiffs who, in the words of a U.S. magistrate judge, file infringement lawsuits as a profit-making scheme rather than as a deterrent. I can agree with that. There are reports. We went over a report last week from Fox Entertainment in Korea, where a representative from Fox, an attorney from Fox, told a room full of lawyers, including myself, that watermarking individual downloads of authorized downloads makes it easier to deter copyright infringement of this kind. And yet, as far as I know, I could be corrected, these companies do not use any sort of individual watermarking technology, nor do they attempt to trace the thing back to their source. Now that said, in the interest of not defaming them, I have received reports that there's some new things going on and that these copyright trolls may be including lines in their cases that say things like, we are also conducting a criminal investigation in collaboration with authorities. So I don't know. Maybe the authorities are working with these copyright trolls and saying, hey, we don't like this copyright trolling you're doing. Collaborate with us or else, either help us find the actual, people who are contributing to the infringement versus the people who are simply benefiting from a download here or there. Again, I really can't fall on the side of piracy and say that it's not infringement, because it is infringement. What I disagree with is the amount of damages. I disagree with how much the people have to pay, even to their lawyer, even to me, because the amount of work that's involved is so high. It would be like, instead of getting a speeding ticket, your car is totaled. That's really kind of what it's like. Like, you're driving down the road and they catch you speeding, so your car's totaled. It's like, wait a minute, there's some huge disconnect here. Like, I can pay for a speeding ticket. Oh, we don't want money for a speeding ticket. We want more money. That's not enough. So, let's continue. These suits typically involve pornography or independent films that performed poorly. True. They rely on poorly substantiated form pleading and are targeted indiscriminately at non-infringers as well as infringers. Yes, sometimes they do include poorly substantiated form pleading. Some of the cases, though, are really just the same case over and over again, so they really do include the same information in each case and then simply change the names and the list of infringements. I'm not defending the practice of wantonly suing people, but it is totally normal to use forms to make things easier when you're repeating things. They use the threat of statutory damages of up to $150,000 for a single download, tough talk, and technological doublespeak to intimidate even innocent defendants into settling. And they're citing Matthew Sagg and Jake Haskell's Defense Against the Dark Arts of Copyright Trolling, 103 Iowa Law Review 571 at 573, a 2018 Law Review article. Some also use the stigma of being publicly associated with pornography downloads to coerce settlements. Yes, we saw that with Prenda Law. By targeting thousands of defendants at once and demanding cash settlements priced at below the cost of legal defense, copyright trolls can turn significant profit whether or not their claims actually hold up in court. Yes, so far this is absolutely 100%, as far as I can tell, 100% true. Again, maybe the hyperbole about, they rely on poorly substantiated, sometimes. Some plaintiffs sometimes do poorly substantiate their pleadings. Yes, absolutely. It's not every single one of them. I don't think they can all be categorized as exactly the same, though I'm not defending them. I'm really not defending their practices. I just want to make sure that we have accurate accusations here. The scope of this problem is staggering. Between 2014 and 2016, copyright troll lawsuits constituted just under 50% of all copyright cases on the federal dockets. These cases dominated the copyright dockets of judicial districts in 18 states, including Pennsylvania. Since 2010, researchers have conservatively estimated the number of people targeted at over 170,000. Copyright trolling has a human cost. Targets of the scheme have included elderly retirees who don't use the internet, who are often coerced into paying settlements. Others are recent immigrants and temporary workers whose limited knowledge of the U.S. court system makes them easy targets, and deployed service members who may fail to respond to a summons. Still others are homeowners, apartment managers, and leaseholders. The person whose name is on the internet service bill. Copyright trolls force them to choose between paying a cash settlement or becoming part of the shakedown by interrogating their tenants, family members, roommates, or house guests about their internet use, despite having no legal responsibility to police that use. And that's what they're talking about there is probably the most egregious part of it, is these plaintiffs don't have a legal duty to prevent or take any steps to mitigate or reduce or go after the primary infringer. Instead, they seem to target the end user, which again, there's not a law against it, but it catches innocent people in the net. My only disagreement so far with this is they have not talked about the ratio. And while I don't want to talk about my personal and confidential experience with the ratio, please read between the lines and understand that they have not discussed the ratio of actual infringers who are caught to innocent infringers who are caught. I'm talking about the most egregious cases being the innocent people who are caught up in this because they really didn't do anything more than own an internet connection. The federal courts are reining in these abuses by demanding specific and reliable evidence of infringement, more than boilerplate allegations, before issuing subpoenas for the identity of an alleged infringer. Some federal courts have also undertaken reviews of copyright troll plaintiffs' communications with their targets with an eye to preventing coercion and intimidation. These reforms have reduced the financial incentive for the abusive business model of copyright trolling. Now, here's what they might be talking about. There might be some things that I don't know have happened yet. Sometimes it takes time for these things to filter through, and since there are thousands of cases, we don't always know what happened in a case in California yesterday if it didn't get reported anywhere. We do rely on our network of attorney colleagues to tell us when they win these things. So if there has been something that they're alluding to here recently, I don't know what it is. What I think they're talking about are things like I think it was Wisconsin or Minnesota Exhibit C. There was a district court that they identified that a copyright troll plaintiff was including an exhibit of allegedly infringing uses of third-party material, not the plaintiff's material. So they were allegedly trying to corroborate, hey, we found an infringer, look, they infringe in these other ways as well. But they didn't have standing to assert those infringements, and so the judge actually sanctioned them and fined them $200 per case, forced them to never file an Exhibit C of that nature again. And so that's one of the abuses that's been reined in. Sorry, I have a hair in my eye. Another one was the Prendle Law story. We did a video on this. The Prendle Law perpetrators pled guilty, and I don't know if I've seen the sentence yet. There's going to be a sentence at some point. but they even admitted to making their own adult videos, which they then uploaded to the internet to share on the Pirate Bay and other BitTorrent trackers, which they then would sue the downloaders of, saying that they did not have permission to download it. Of course they had permission to download it. You put it up there for them. So that's the difference. If you don't put it up there for them, then they're not authorized. If you don't authorize them, then they're not authorized. So that's, I think, what they're talking about, is the courts have discovered that stuff and prevented that stuff. And the courts regularly prevent new plaintiffs from filing things that just say, we have a claim, give us the identity. They require them to allege specific facts in a pleading that will have to be, the facts, that the veracity of, will be able to be challenged later. The C.A.S.E Act, which is the new act that we're talking about here, threatens to derail this process by creating an alternative forum where these carefully crafted protections do not apply. Under the C.A.S.E Act's provisions, legally unsophisticated defendants, the kind most often targeted by copyright trolls, are likely to find themselves bound by the judgments of a non-judicial body in faraway Washington, D.C., with few, if any, avenues for appeal. The statutory damages of up to $30,000 proposed in the C.A.S.E Act, while less than the $150,000 maximum in federal court, are still a daunting amount to many people in the U.S., more than high enough to coerce Internet users into paying settlements of $2,000 to $8,000. So they are alleging that these settlements are around $2,000 to $8,000 for many of these cases on average. Under the Act, a plaintiff engaged in copyright trolling would need not show any evidence of actual harm in order to recover statutory damages. Yes, that's what statutory damages are, though. We have sort of, Congress has agreed, or Congress has said in previous acts, that it's hard to show actual harm for piracy in the real world or the internet. It's hard to show, well, would you have made $8 per copy? Would you have made $1.50 per copy? Would Susie in a rural area pay the same price as John in a city area? Would Jane with a decent paying job pay the same as disabled Joe, an elder retired veteran? Who knows? So the number has to be assigned, and you have to pay somebody to argue over the number, and pay an expert on one side for the number, and pay an expert on the other side for the number, and you get the idea. So the whole point of statutory damages is that you get a number without having to go through the proof of actual damage. I kind of agree with that. As a person who makes videos, as a copyright creator, I want to have statutory damages available to me. And I like the idea of having a small claims court for copyright, but I'm also a representative of people who are hurt by those sorts of trolling acts. So I definitely am more on board with the EFF on this one than... We need to have these protections of law incorporated into the C.A.S.E Act, then, is what I'm seeing so far. Unlike the federal courts, statutory damages could be awarded under the C.A.S.E Act even for copyrights that are not registered with the Copyright Office before the alleged infringement began. This means that copyright trolls will be able to threaten home internet users with life-altering damages and profit from those threats based on works with no commercial or artistic value. Yes, if that's really what the C.A.S.E Act does, I did not know that about the C.A.S.E Act. If it allows statutory damages for works that are not registered, that's not the law. The law currently says that statutory damages are only for properly registered works with the Copyright Office. Otherwise, you have only actual damages available to you. So this altering that's something I disagree with. The C.A.S.E Act should not be altering the regime of statutory damages like that. It also gives the Copyright Office the authority to issue subpoenas for information about internet subscribers. Well, of course, they're John Does. How would you ever accuse someone of anything? The safeguards for internet users' privacy established in the federal courts will not apply. Well, that part's bad. They're should still have to apply case law precedent and all that. In fact, the bill doesn't even require that a copyright holder state a plausible claim for copyright infringement before requesting a subpoena, a basic requirement in federal court. Yes, this is the pleading standard, the notice and pleading standard for federal copyright claims, or any federal claim, really. And it says that you have to have a plausible claim, and it has to be stated plainly so that the defendant knows what they're being accused of. This all needs to be preserved in the C.A.S.E Act. I mean, come on, guys, we're not going to gut the copyright law here. If that's really what the C.A.S.E Act is doing, then I'm against the C.A.S.E Act, guys. Given that the Copyright Office views copyright holders as its customers, we fear that the office will not protect the privacy of home and business internet subscribers against invasion by copyright holders who build a business based on monetizing litigation threats, including those who threaten to publicly accuse their targets of viewing pornography. Another troubling provision of the C.A.S.E Act would permit the Copyright Office to dispense with even the minimal procedural protections established in the bill for claims of $5,000 or less. These smaller claims, which are still at or above the largest allowed in small claims court in 21 states, would be decided by a single claims officer in a summary procedure on the slimmest of evidence, yet still produce judgments enforceable in federal court with no meaningful right of appeal. Well, again, you have to preserve the right to appeal, people. Come on, what the heck? It can't be behind the C.A.S.E Act if you're not preserving the copyright law and the right to appeal. That's due process right there, the right to appeal. Finally, the federal courts are extremely cautious when granting default judgments and regularly set them aside to avoid injustice to unsophisticated defendants. Nothing in the C.A.S.E Act requires the Copyright Office to show the same concern for the rights of defendants. At a minimum, a requirement that small claims procedures cannot commence unless defendants affirmatively opt into those procedures would give the Copyright Office an incentive to ensure that defendants' procedural and substantive rights are upheld. A truly fair process will be attractive to both copyright holders and those accused of infringement. We recognize that federal litigation can be expensive, making the pursuit of many small dollar value claims impractical for copyright holders. But we believe that much of that expense results from the procedures that promote fairness, refined through the decades of use. Creating a new parallel system that allows copyright holders to dispense with those procedures invites abuse, especially given the Copyright Office's institutional bias. In attempting to solve a problem for some copyright holders, Congress must not create new incentives for unscrupulous litigation businesses to abuse and exploit ordinary internet users. As advocates for your constituents, we ask you to oppose the C.A.S.E Act. So, it's an interesting problem. I agree with much of what they said. I do feel like I'm on their side and that I'm against this C.A.S.E Act as written. I'm not against the idea of a copyright small claims court that ends up costing defendants less to defend themselves. That's the problem here, is that these defendants don't have the money to pay for what is a fairly slight abuse. We can argue. I'm happy to argue. This is a perfectly disagreeable thing. You're not a bad person if you think that people deserve thousands of dollars in punishment for online piracy. I don't. I think that hundreds of dollars might be okay. I don't think thousands of dollars would be okay. Now, if it was only hundreds of dollars, maybe people would pirate more. I don't know. Maybe the fact that it's thousands of dollars is the thing limiting piracy right now. But most of my clients that are calling me are saying, I never knew this was really that illegal. I never knew that there was this kind of punishment for this kind of crime. Now, first of all, it's not a crime. So copyright infringement is a crime, but what we're talking about is civil copyright infringement, and we're talking about civil damages. So this is civil liability and damages and claims, and not criminal acts. The FBI could investigate, or I don't know how it would be done internationally, but the FBI could investigate domestic piracy and bring charges of copyright infringement. This is civil, but the problem with civil is that civil means that you have a lower standard of evidence for the plaintiff. Normally, the prosecutor has to prove their case beyond a reasonable doubt, but a copyright plaintiff only has to prove their case more convincingly than the opposing side by preponderance of the evidence. So whoever wins the 50-50 tug of war wins the case, and the rules are that your tugs are only the appropriate evidence and testimony, relevant evidence and testimony in the case. So this is concerning. If this became law, it sounds like any copyright plaintiff would be able to make a BitTorrent-style file-sharing IP address accusation, unveil the subscriber of the IP address, and then that subscriber has to respond whether they are the infringer or not. Now, maybe we're getting ahead of us. Some people, including some judges, would definitely say, well, they saw legitimate infringement, so if they saw legitimate infringement, shouldn't they be allowed to ask the subscriber who the infringer is? And if the infringer is the subscriber, go after the subscriber? Yeah, I don't see a problem with that. If you see infringement, if I saw my videos online and they were just being wantonly pirated, and they were obviously, I'm not Game of Thrones, guys. I know you're not pirating my videos for that, and I honestly don't care. But if I was producing a high-budget production and I felt I was losing money, or maybe my high-budget production didn't make its high budget back, I'd be motivated to figure out where I could monetize things. I would not fall on the side of suing people, but some of these people will, and they're within their right to do so because they saw legitimate infringement. One of the abuses we're trying to prevent, though, is potential plaintiffs who don't have a legitimate claim, didn't pay for a complete investigation, are just maybe going on their own computer and joining a BitTorrent swarm and just writing down IP addresses and then copying somebody else's pleading, changing the facts to suit their situation, and then filing that in court. There's been a couple of those, and they have to get handled pretty quickly and heavily, otherwise they become the next Malibu Media, which is, I think, what Strike 3 Holdings is doing now. Now, Strike 3 Holdings was accused by Christopher Lynch of not conducting the investigations that they say they do, so we're all paying attention to that. And I'm prepared to defend Strike 3 Holdings cases if someone wants to defend. So what did you think of the C.A.S.E Act as presented by the Electronic Frontier Foundation, and would you be interested in a follow-up video where we go over whatever the current version of the C.A.S.E Act is and see who's telling the truth here? Is the C.A.S.E Act really some bastion of copyright small claims, or is it really a bastion for copyright trolls? Are they one and the same? Let me know your thoughts in the comments below. Like the video, of course, if you liked it. Dislike the video if you disliked it. Don't forget to subscribe if you want to see more of my videos, and definitely click the bell if you want to see all of my videos. Thank you very much to all of our Patreon supporters. This channel is made possible by our supporters. Thank you very much to Kareem Harper, who is sponsoring another month at the $500 level. Very, very much appreciated. And we're looking forward to producing a video about the Cambridge Analytica Facebook data privacy situation very, very shortly here. Thank you very much to DJ Gilcrease, John Steele, Gavin Barnard, Andy the God Slain, Kyle Mudrock, Evie, Verimantane, John H. Anderson, Sean McNamara, Michael Pierce, and William Gonzalez for sponsoring May at the $50 level. And thank you very much to the $5 plus supporters who are scrolling on the screen now and on the LED panel behind you, which is why we did this awkward cut to now me 2 days later in the same outfit. So thank you very much for your support. Really appreciate you sponsoring our efforts to educate the lawful masses. I am, of course, Leonard French, your favorite copyright attorney. Happy Wednesday. I'll see you in the next video. Love you all. Bye.